Okay, I see everyone is settling in, so welcome and thank you for joining us. It's wonderful to be here with all of you. I'm Carol Allen Scannell, Director of Development here at GLAD, GLBTQ Legal Advocates and Defenders. I've been here for just over a month, so for those I haven't had the chance to meet, it's great to see you here. Thank you for joining us today for a conversation about a case before the U.S. Supreme Court I know many of us have been keeping an eye on. It's called Fulton versus the City of Philadelphia, and it has potentially significant implications for the rights of LGBTQ people, Black and Brown people, women, and people of minority faiths. With me today are GLAD's Legal Director, Gary Buseck, and Executive Director, Jansen Wu, who will be moderating today's conversation. Hi, Gary and Jansen. It's good to see you.
Hello.
So before we get started, let me review a few housekeeping items. This webinar is being recorded, so if you do not want your face recorded, you can turn off your video by selecting Stop Video at the bottom of your Zoom window. We'd love to know who you are, though, so if you haven't yet, please add your name by clicking on the three dots in the upper right corner of your frame and select Rename. Let us know who you are. We'll be taking questions and comments in the chat box, and you can select at the bottom of your window also. We'll do our best to respond as many as time allows. Otherwise, we'll be muting everyone except the speakers today to ensure good audio quality. Closed captioning should appear at the bottom of your screen. If you would also like to use your iPhone or iPad, there's a link in the chat box. I'll say that there. Finally, I want to thank our GLAD supporters who make our work possible, especially our Equal Justice Council leadership donors. If you're interested in supporting GLAD's critical work, I welcome you to reach out to me at any time or visit us on our website, glad.org. You can sign up for our email list there, and of course, don't forget to follow us on Facebook, Twitter, and Instagram. Okay, we have a lot to talk about today, so I'm going to turn it over to you, Jansen, to get us started.
Thank you so much, Carol, and it's so great to see all of you. Thank you for joining us. So, Gary, let's just get right into it. We know that there's a question at the center of the Fulton case. It's about what leeway a religious organization, in this case Catholic Social Services, gets, which receives taxpayer money to carry out a service under a government contract. What leeway does Catholic Social Services, or CSS, have to ignore laws that protect LGBTQ people and others from discrimination? That said, before we get into the details of this upcoming case, the court considered a similar question a couple of years ago, didn't it, in the Masterpiece Cake Shop case, but kind of avoided fully deciding that. Why do you think then they took this case now?
Well, thanks, Jansen, and welcome everyone. Please forgive me if my first kind of Zoom one of these, so hopefully I will come across clearly and directly on this. I think probably most of you know that the law around religion in the United States was settled for a good long time, but we now have a Supreme Court that in the last, say within the last 10 years, maybe more so in the last 5, they have clearly signaled that they are very interested in taking a second look at various aspects of how the Free Exercise Clause particularly and the Establishment Clause operate in American jurisprudence. And so we know that questions are coming, have been coming in a lot of different areas. You've probably read about it, but one that concerns us the most and concerns us today is this question of the interrelationship between anti-discrimination laws and what they refer to as religious liberty. And so 2 years ago, you all saw the case involving the baker who refused to bake a wedding cake for a same-sex couple. And that went all the way to the Supreme Court. I think, again, because the court was interested in this question of, do they want to draw the lines differently on religious liberty? And in essence, Masterpiece Cake was a punt. They didn't resolve the question. It turned on, and we'll talk about this a little bit later, but about perceived hostility to the baker by the deciders in Colorado, their Commission of Human Rights. And so they made a decision where they didn't exactly talk about the scope of free exercise. They didn't talk about free speech, which was how the claim was actually framed up by the baker. And so we got to the point where we assumed that they were just going to come back and to this issue again. And here we are.
Here we are. So can you describe then how this particular case involving Catholic Social Services came about, and why are we watching it so closely? What's so important about this one?
Yeah, so now going back into 2018, Catholic Social Services in Philadelphia, which I may at times refer to as CSS for short, but Catholic Social Services has a contract with the city of Philadelphia, had a contract with the city of Philadelphia. And as you may know, the foster care system is a huge part of government operations. The state and the municipalities take charge of children who are taken out of their home. And let's put aside the question of the problems with that system and why children, and particularly LGBT children and minority children, are taken from their homes and whether this system is really working. But the fact of the matter, this system does exist. And the government has legal custody of children taken from their parents. And they tend to, in modern times, work with private entities, both secular and religious, to carry out many of those functions in the recruitment of foster parents, the placement of foster children, the reunification of families, the eventual adoption of some of these children. And in this case, the city of Philadelphia had a contract with CSS, and then a newspaper story broke that in fact, CSS and another religious-based agency were actually refusing to work with same-sex couples or with unmarried heterosexual couples. That news coming to the city caused an investigation to begin and some negotiations to begin. And as a result of that, when CSS decided that they could not comply with the contractual terms of the contract with the city that required them not to discriminate on a variety of categories, but including sexual orientation, the city put a freeze on the contract with them. There's a lot of nuances to this. There's a lot of other ways in which CSS still contracts with the city of Philadelphia, and we may touch on that a little bit. But that refusal to allow the city, or to allow CSS to move forward under the terms that they wanted to dictate, led the city to freeze the contract and led CSS to file a federal lawsuit. They sought a preliminary injunction to force the city to grant them a contract on the terms that they were willing to comply with. The federal district court held a 3-day hearing, made factual findings, and denied the injunction. That went on appeal to the Third Circuit Court of Appeals, which also denied them the injunction. They sought an emergency stay from the US Supreme Court, which denied it, but then they filed a petition for certiorari, and the US Supreme Court granted the request to hear the case. And so that's how we got to where we are today.
So if I'm understanding this correct, the case hasn't even been decided yet. This is a preliminary injunction that's on appeal to the US Supreme Court. And at the risk of it getting a little too wonky, is that unusual? Is that surprising for the Supreme Court to take up an appeal on a preliminary injunction?
I think it is. And let me say a couple things about surprisingness of this case. First is the issue of preliminary injunction. The US Supreme Court generally wants to be involved when a matter has come to a final resolution. And then they can review what the lower courts have actually decided to resolve the dispute between the parties. Here with a preliminary injunction, theoretically, the court can grant a preliminary injunction and then ultimately, when they have a trial on the merits, rule against the plaintiff and take that injunction away. So it is a little bit surprising that they got involved here in this. In addition, they have another wedding provider case pending there, not a baker this time, but a florist. And that case has been hanging there for a while. And I think a lot of us thought that the court would take that case in that kind of narrow area of wedding services and take another stab at trying to get a majority to resolve that question. Instead, they take this case that involves the government, a government function dealing with foster children, where they contract out to a private entity to carry out the government's job, and now ask the question, are government contractors allowed to raise religious objections to the term of the contract that the government has put out there for bid? It seems quite settled in the law that if you are a contractor with the government gets to tell you what that contract looks like and how you carry it out. And it doesn't violate your free speech rights or your free exercise rights because the contract requires something like the non-discrimination provision here. So we would expect, up until the court taking this case, that this was kind of a no-brainer. That, you know, if you don't want this contract, don't take it. If you can't abide by how the government wants its program to be run, walk away. So that is the state of the law. And so in some ways, I think some of us are scratching our heads saying, why did the court put itself in this very difficult spot? Because, as we're going to talk about, the consequences are potentially enormous. But it probably speaks to the fact that the court is interested in, I mean, frankly, I think they are troubled by mainstream religion being excluded in this fashion, and there must be a gut instinct that this isn't equal treatment in some fashion. And so that's how the case is setting up, with one more aspect that I think we're going to get to eventually.
Got it. So it sounds like this case has the potential to, you know, fairly broadly upend settled law on the balance of, you know, religious liberties and non-discrimination, particularly in the context of government contracts. In some ways, this is kind of one of the hardest cases our opponents could have brought forward to the court and for the court to take it on. From our perspective, you know, it sounds as if we're looking to maintain the status quo, but I also just want to be really clear. No one's arguing that CSS doesn't have a right to his religious beliefs. Is that right?
And that's, yes, and that's absolutely correct. I think we all know, and I think a GLAD position throughout and ongoing is that the right of free exercise of religion is a fundamental right in our Constitution. And we have no problem with that having even a primary place in our constitutional jurisprudence. So we are not, I mean, obviously there are plenty of LGBT people of faith, and there are plenty of views in mainstream religion supportive of LGBT people. We have no quarrel with free exercise rights. And I think in this case, it's interesting, and you're going to see a lot on the other side of this, but the city of Philadelphia tried very hard to find a way to keep working in the foster care arena with CSS. They entered into negotiations to attempt to resolve this dispute. That was $2 million worth of contracts. CSS has another $17.5 million worth of contracts with the city of Philadelphia for other aspects of caring for children that are in the government's care. You know, it's also true that what CSS says is, and they use this word very carefully, I think, they say it's our understanding that we are required to endorse the families that we certify, so that we would be endorsing a same-sex married couple. The fact of the matter is that is simply untrue. There's actually an amicus brief by the Commonwealth of Pennsylvania, it's very short and sweet, which just says, here's what Pennsylvania law requires an agency who's certifying foster parents to certify. And it has nothing to do with the marital relationship of the parties. It's about whether they can be adequate and successful foster parents. And so there is even a very strong argument here that there isn't even a burden on CSS's religious beliefs here, because they are not being asked to endorse anybody.
Yeah, and you know, certainly clear that the use of that word endorse is to, support their claims that there's some type of coerced speech here in order to get them under that doctrine of cases under the First Amendment. But, I've got one question in the chat, which I think is a relatively quick one. Let's just take it right now. A question from Holly. Hello, Holly. Holly is a good friend of GLAD, but also of the ACLU, who is intervened in this case actually, and will be briefing as part of with the city of Philadelphia as one of the parties in this case. Holly's question is, who were the justices who granted cert? Do we know that?
No, we never do know that. We just know that it takes 4 votes to grant cert in a case. We can probably have a pretty good guess as to who those 4 are. And as you know, 4 justices grant a case and they need 5 votes to win. And so often the question of the grant is those 4 individuals making a fairly educated guess that they have a 5th vote. And so I think we can probably all kind of think that the people that are plausibly open to CSS's claim would be Justices Alito, Kavanaugh, Thomas, and Gorsuch. And that the 5th vote that they hope they can gain is that of the Chief Justice. Now, none of that is, I mean, just to say, in this new era of rethinking religious liberty, the court hasn't broken down so much along like what partisan lines or how you might expect, because the Masterpiece Cake decision was 7-2 in favor of the baker. Now, it didn't decide the fundamental issue, but it still was a 7-2 decision. And we've had a couple of other cases along the way. You may have seen the ministerial exception case that came out this year involving, do discrimination laws apply to teachers in Catholic schools? And the Catholic schools won that case, and I think the vote again was 7-2. So Justice Breyer and Justice Kagan are definitely in play and open to new ways of looking at how the religion clauses should operate in American society.
And of course, Justice Gorsuch is the justice who authored the recent victory in the Title VII cases, the Buseck cases just last June. And so it's a good reminder that even as we look at individual cases, they all fit within a larger landscape. So going back now to the settled doctrine that we've been talking about that's at stake here, the Supreme Court has been grappling with the right balance between religious liberty and non-discrimination protections for decades. So what's different here?
Well, I guess you could say what's different here are gay people and marriage. But you also say that, I guess, more broadly or more neutrally, that again, there is a move to reconsider whether the lines have been drawn in the right place. And in this balance between religious liberty and non-discrimination laws, I mean, the court has resolved that in reference to race. There's no doubt about that. You don't have a right to a religious objection to a non-discrimination law based on race. Settled, not going to change. And it's probably also settled with regard to sex, but it has not been settled with regard to sexual orientation. And that, of course, is what came up in Masterpiece Cake. And one of the questions that is behind that, and this is getting a little wonky, I suppose, but in 1990, there was an important free exercise case in the Supreme Court that we'll call Smith. And in the Smith case, and you may have heard about this, involved two Native American employees who it was discovered had smoked peyote as part of a religious service, and they lost their job and they applied for unemployment benefits and were denied. And they challenged it based upon their free exercise rights. And under the law that existed at the time, the way that question would have played out was, first question, did they have a substantial burden on their religious practice? And the answer would have been yes. And then the next question would have been, did the state have a compelling interest, regardless of that burden on the individuals? Did they have a compelling interest in enforcing the law? Here, a criminal law on the ingestion of a controlled substance. And if they had a compelling interest, were they enforcing it in the least restrictive way possible. In other words, could they have done it differently that would have protected the rights of these two individuals and still have been able to accomplish their compelling interest? That's how that case would have been decided, would have been resolved. Justice Scalia, in that case, for the Supreme Court, changed the playing field. He said, if the state has adopted a neutral and generally applicable law, there are no exemptions to it. You take your hit on your religious interests, because that's the only way the world is going to work. Otherwise, everybody becomes a law unto themselves. We have anarchy, and because we have such diversity in America, we just can't do it. Okay? And for the last 30 years, that's been the state of free exercise law. And that means why in Masterpiece Cake, it was primarily argued as a speech case, because they really didn't have a free exercise case, because the non-discrimination law in Colorado applicable to the baker was neutral, applicable to everyone. Now there is an exception though. It can be a neutral and generally applicable law, but if somehow it's really targeting religious people, or if there's been hostility expressed to religious people in carrying it out, you still might win if you're the plaintiff. And that's what happened in Masterpiece Cake. They decided that there was some targeting going on here of religious folks. Now, we could fight about that. We don't necessarily think the way the court got around to that, but again, that was their punt in that case. Now, in the CSS case here in Philadelphia, they have put squarely before the court whether the Smith case ought to be overturned and go back to the test that existed pre-Smith. And the court accepted that question. So they are going to presumably address that question and either keep the Smith test alive or go back to what we call the strict scrutiny test of a compelling state interest and least restrictive means. So that's a huge part of this case at this point.
That is certainly very concerning, and it, makes clear what our opponents are looking for, at the end of the day, which is an overturning of the Smith case. We saw that in the parties' briefs, and we also saw them in the amicus briefs as well, too, supporting Catholic Social Services, which were just filed a few weeks ago. Gary, could you talk a little bit more about some of the other arguments that we saw put forward in those amicus briefs for our opponents, and which ones kind of raised the biggest red flags for you?
Well, I found it kind of surprising. Again, looking back at Masterpiece Cake, the baker had 50 amicus briefs filed in support of his position. And at that time, there was a little talk about Smith, but there was a lot of talk about there's no dignitary harm to gay people in this case. A dozen briefs on there's no discrimination here. This isn't discriminating against gay people. The baker will serve gay people. He just can't deal with same-sex marriage. There were half a dozen briefs that actually said public accommodations law are horrible. They should all be taken away, except for race. But every other way, there should be no public accommodations law. And there was a lot of discussion about race being different. Now, with this case, there's a smaller number. There's 34 amicus briefs. 17 of them, so half of them are all about why Smith needs to go. That seems to be, for the amici, their key focus here. Beyond that, there are 5 briefs that are really focused on what I mentioned a minute ago about it not being neutral or generally applicable. They are hammering away at, and so is CSS, that they think they were targeted. They believe that the non-discrimination law or ordinance in Philadelphia was never even thought about as being applied to foster care agencies until they learned that what Catholic Charities was doing around same-sex couples. And they suddenly decided, changed their whole position to target them because of their religious beliefs. And it's interesting, as I said to you at the beginning, they actually sat down with CSS to try to negotiate this. And the commissioner, who was also a practicing Catholic, said to the head of Catholic Social Services, why can't we do what Pope Francis would do here? And they took that as a hostile religious argument. Now, the Third Circuit Court of Appeals said, gee, that looked more like she was just trying to find common ground with a co-religionist as a way to resolve the case and to move this to some better place. But they continually pound away at the fact that this was an attack on religion. It was trying to force a different view of what Catholic teaching ought to be. And then the city council passed a resolution in which they said nice things about religion, but they said we can't harbor discrimination under the guise of religion's views. And that little word guise doesn't sound good, right? It sounds like it's hostile towards religion. It sounds like it's fake. And they rely on that language. And so, true to what the court did in Masterpiece, they could punt on this case too and find that there was hostility expressed such that Catholic Social Services should win something here, but that it doesn't apply any more broadly.
Got it. And let's talk about the outcomes, since we're already there. So it sounds like the court could rule in CSS's favor, but do it in a fairly narrow way, like they did in Masterpiece Cake, and just really focus on the actions and words of the city of Philadelphia, but not, attempt to create some broader constitutional principle. Of course, they could just reject CSS's claims outright, and we would have a victory on that. But then it sounds as if there is, the possibility that they could upend federal constitutional law and create a brand new constitutional right to be exempted from non-discrimination laws. Am I getting that right, Gary?
Yeah, unfortunately, yes. Yeah, I mean, I think I'd like to start from the other end. Every once in a while, the court takes a case and then decides they do kind of an oops, maybe we shouldn't have taken this case. And they do they dismiss certiorari as improvidently granted. I have this fantasy that after seeing all this briefing and realizing how difficult this case is, and realizing that all of the facts found by the district court in this case are square against any finding of hostility or targeting, that they might say, this was a bad choice to take this case, okay? So I hold out a little bit of fantasy of that. I also think, we should win this case because, as I said at the top, the fact that the government is granting contracts to carry out a government service paid for by taxpayer funds has never been a doubt that you don't get to raise religious objections to carrying out that contract under the contract's terms. You just don't take the contract if you don't want to, and that's not a burden on your religious exercise. So I hold out hope too that is the winning argument here. At the same time, it could be a narrow win like Masterpiece, but if it isn't, if the court were to find that somehow there is a valid First Amendment free exercise right to determine how you will perform a government contract, that can be earth-shaking, right? I mean, they could somehow find a way to limit this at the outset just to foster care or child welfare services, but it's hard. I can't immediately envision how they might do that, but the court is very creative, so they may find a way. There's a huge amount of amicus briefing on their side about how important religion has been since the nation's founding in regard to care of orphan children. So they go back and show that the first orphanages were founded by the Catholic Church and very early in the colonial era by the Jewish faith, that there are, and they want to argue that history, that deep history that goes back to the founding, suggests that the government can't now, even though it is the entity that controls child welfare, it can't just kick these people to the curb and has to accommodate their religious beliefs. So maybe the court's going to find a way to get there and just give something to foster care and adoption services. But the broader principle that they're arguing for seemingly would apply across the board to every government contract, every service, and it applies then seemingly to every government employee. And therefore, could government employees begin again to say, oh, I'm not going to give you that marriage license because I don't believe in giving them to same-sex couples. I'm going to thwart your Social Security, spousal Social Security claim because I don't believe in it. I mean, are those things that we think, I mean, they seem inconceivable. It's really hard to imagine, but the principle they're asking for here, if they seemingly would apply to all government contracts, to all government employees, and then conceivably to any public accommodation law, so to any private party as well. And again, that's, I guess, the reason for thinking, why did they venture into this thicket? Because it is really big, potentially.
And just to add one more example and to answer a question we have here from Joyce Kaufman, it could also apply to private employers as well too, and then undermine the full force of the recent Buseck victory that we, of last June. So, in the time we have remaining, Gary, could you talk a little bit about, and I love that you're always the optimistic lad, you're always, thinking that we are going to either dodge a loss or win. Like, what are we doing on our side? What is GLAAD doing to ensure the best possible outcome here? I know that there was a whole number of amicus briefs supporting City of Philadelphia just passed, including GLAAD's own amicus brief. Could you talk a little bit more about the brief that GLAAD filed, as well as others that you thought might have an impact?
Yes, yeah, and I mean, the GLAAD brief is a very sweet little brief, and it was driven almost wholly by Mary Bonato, and she did an awesome job on it with really supporting help from Jennifer and Polly, who provided key aspects in the process. So it's hard to it's a little hard to summarize, but I think the point we really wanted to make was that over the last 25 years, starting in Romer v. Evans, some of you all know about the Colorado amendment that would have barred all laws protecting sexual orientation discrimination, and right through Lawrence on sodomy laws, and through Windsor on DOMA and Obergefell, and even in Masterpiece, where the court was clear about the question of public accommodations have to be open to all, including gay people, and then to Bostock with such an important decision. That whole panoply of cases from the Supreme Court, along with other things that have happened in the legislative sphere that are pro-LGBT, we have started to see a world in which we are equal citizens. And the question is, so inclusion has really been the message from the Supreme Court for a good long time now in incremental steps. And if a loss in this case, a broad exemption, you could say in a way that it would establish exclusion as the rule. And so our brief is to try to say to the court, we are finally at the doorstep of citizenship. And this could be a devastating attack on that. And you shouldn't do it. It's contrary to the law. It's not good policy. And in fact, we know how to protect religion. We've done it forever. We have a balance in religion versus non-discrimination, and legislators can deal with it. Let them. Don't create a constitutional rule on this subject that will cause incredible harm. And I think that's generally what our amicus brief said. Oh, and then you asked about what other briefs were out there. There were 46 amicus briefs filed on our side. There is a really nice little brief, and you can find all these on the Supreme Court's website. They're all available to be downloaded. There's a really nice brief by a small group of scholars who take head on the race analogy. And they to all of the other side, because the other side's never going to say that race isn't a protected category that is protected from religious liberty. They're just saying sexual orientation is different. It doesn't have the pedigree. It isn't as important an interest because of America's history. And these scholars make a point of saying, look, court, you resolved this question on race back in 1968 in a case called Piggy Park, where a public accommodation argued that, well, they had a right to exclude Black people because it was their religious belief. And the court really said, that's nonsense. And now these scholars are saying, well, all the other side is really saying is, well, those were bigots in those days, and we're not bigots today. And these scholars are saying, nobody's talking about bigots anywhere, then or now. Those people in 1968, whether we like it or not, had mainstream religious beliefs in segregationist theology. No, we don't call anybody a bigot. It's just what we don't do in our law is exclude people from the protection of non-discrimination. So that's a really nice little brief that's out there. There are scholars' briefs on religion, on government contracts, on history, on constitutional law. There's a lot of briefs from religious folks, whether they're top-end leaders or lay people or groups like Dignity, the LGBT Catholic group. There's briefs from 22 states. And because I always have to think who's going to win or lose, they only had 13 states. We had 22 states and the District of Columbia, led by the AG in Massachusetts. And what they did nicely was, the other side has a lot of talk about, if you take this away from Catholic social services, you're going to deplete the pool of available foster parents. It's just going to have a devastating impact. And we know that what happened in Philadelphia happened here in Massachusetts years ago, when a story broke in the Boston Globe about Catholic social services here not doing adoptions with gay people. And they ended up losing their contract. It happened in Illinois almost 10 years ago, and that didn't come out in Catholic social services' favor either. And it happened in the District of Columbia. And one of the things this brief of the states does is say, you know what? There was no harm caused by that to foster children. No harm at all. Every other piece of the system picked up the slack caused by their departure. And I think that's a really important thing for the court to know. And then we have 172 members of Congress who submitted a brief, and they had 76. So we had 100 more congressional members than they did. And I think I mentioned there's a sweet little Commonwealth of Pennsylvania brief on exactly what Pennsylvania requires of certification of foster parents. And then lastly, I think this is the wildest brief. It's filed by a group of atheists. And their main point is, well, if you think hostility towards CSS gets them a free pass to do whatever they like, take a look at the hostility towards atheists in America. We won't have to comply with any law. Do you want that? And I thought, well, that's a very interesting brief. And there are plenty of others, but
well, that's certainly a lot of briefs for folks to read and to chew on. Going back to the GLAD brief really quickly, one of the points you made, Gary, was about how we're urging the court to allow this balancing of religious liberty versus non-discrimination to be worked out through the legislative process. We have a question from Kirk about how might this impact the Equality Act, and quite simply, if we win this case, the Equality Act hopefully will pass soon, and perhaps in the next term after the elections. And the question about what the right balance is around religious liberty would get decided in the Equality Act. However, if we lose this case in kind of the broadest ways that Gary just put forth, and we really constitutionalize the right to ignore non-discrimination law based upon religious beliefs, that is the supreme law of our land. That would impact and limit, all other decisions and all statutes, both state and federal, including the Equality Act. And so it would prevent the Equality Act to have the full force that we would want to have. So certainly quite a lot is at stake with this case. And there's a lot to think about after this call. And we just learned oral arguments has been scheduled for November 4th. So as we're sitting anxiously trying to figure out what the results of the election are, you can also tune into the arguments, which, you know, are likely to be held by telephone given the pandemic. It's a good chance they'll be streamed online, and so we can all listen to together. And of course, you can always tune back in with GLAD, as we will try our best to provide our best analysis of how the arguments went. Thank you so much, Gary, for that really informative conversation analysis, as always.
Oh, it was nice to be with you all.
And that's about the time we have. So I'll turn it back to you, Carol, to close us out. And you are on mute.
No. So I really appreciate that. It was very informative. And, you know, as the newbie of the crew, I really do appreciate it. So as we wind down our time, I do want to mention that this wraps up our summer series of Justice Hangouts. And it's been wonderful to engage with so many members of our community on important topics. Thank you for being a part of this. We have more good things in the works for the fall, so keep an eye on glad.org for more information, and of course, to keep up with all the ongoing work for justice that you make possible. And speaking of justice, October 16th, it will be GLAD's 21st Annual Spirit of Justice Award celebration, and I hope you'll join us. Visit glad.org/SOJ to learn more and find out how you can attend. And another reminder that you can contact gladanswers.org if you experience discrimination in any context or need legal information or referrals. That's gladanswers, plural.org. Thanks again.